I'd like to introduce Caroline Ryan, who is an Industrial Relations Advisor with Jobs Australia. She's come up for the day to be with us from Victoria. Jobs Australia is the peak body for not-for-profit employment and training services and also acts as an employer association. She's legally qualified and has extensive experience in the industry, industrial and policy. The aim of this session will be to assist you in managing the tensions between managing a workforce within the constraints of the awards and providing accessible and flexible services to people with a disability. It's also an introduction to the NDS workshops that we're looking at running with Jobs Australia over the next couple of months across the regions on flexible employment practices.
Okay. Good afternoon, everyone. Just see if everything is working. Okay. I did meet a number of people in the break who are members of Jobs Australia, so I guess some of you will be familiar with our work, and more recently we've been doing quite a bit of work with NDS around this whole issue of flexible employment practices going into the brave new world of NDIS. So I'm an Industrial Relations Advisor. I'm based in Melbourne, and I work for Jobs Australia, which is the peak body for not-for-profit employment services. But many of you will know that we also run an employer association function for all sorts of community organisations, including the disability sector. And we have a partnership arrangement with NDS around providing industrial relations advice to their members who join in to participate in that part of the program as well. So I'm talking today about juggling some of the tensions between providing more flexibility for clients and their families in the way that you provide services, but equally balancing that tension with the needs of your staff for a different sort of flexibility. We're running a series of workshops on behalf of NDS across Australia on that issue at the moment, and I'll just give you a bit of a taster after the break at 2:30 around some of those flexible employment practices and see if you've got some ideas of your own. But in the first part of the presentation, I want to talk about the industrial relations context and where we're at the moment. You'll all be familiar with the fact that there was a new industrial relations system coming into play in 2009 with the introduction of the Fair Work Act. And since that time, we've had the creation of the modern awards and all that's meant in terms of upheaval, in terms of which conditions are regulated in your workplace. We're now at the stage where those awards are being reviewed again, and it's an opportunity today for all of you to have some sort of input into how you've experienced the operational tensions of using those awards. Particularly, my focus is on the SCADS award, the Social, Community, Home Care and Disability Services Award, because I presume that that's the one that most of you use, and we'll have an opportunity for all of you to have a roundtable discussion about issues you may or may not have with the award and what you think should go forward to Fair Work as part of that review. But firstly, in terms of the context, obviously the theme of the day is change, and we have the Productivity Commission's report finding that the current disability service system basically is broke. And so we've got the introduction of the NDIS and the trial sites and the reports coming through from the trial sites. And of course, we're all awaiting further advice from government as to how quickly or slowly the rollout will continue. But I know that NDS has spearheaded the drivers towards putting you all in the best place possible for the new business environment. I heard that term from someone this morning, so yes, I guess it is a new business environment. And coming from Jobs Australia, I'm very familiar with the contracting out and the privatisation of community services, because the employment services market was created some decade ago, and we're still dealing with the repercussions of that in our role as a peak body at Jobs Australia. So it is a challenge, and I can see that your services are very well supported by NDS in meeting that challenge. But we'll look today at some of the nitty-gritty about how does the industrial relations environment help or hinder, and what sort of ideas do you have for what sort of changes could be made in that environment. Obviously, we've got the move away from block funding towards more individualised funding, where the person with the disability or their family has more choice, and it's no longer a situation where you can provide the services that you have been providing in the past. So there's no going back to business as usual, but I guess one of the largest question marks is all the unknowns that are facing you as organisations. Will you be able to get the labour market you need? How will you develop their skills? What sort of industrial relations hurdles are there, and how can you get around them? And the other issue, which I think is probably very much to the fore, is what competition do you face? We did have some discussion this morning about individuals thinking that they could provide the services that you provide currently, and we have had a few instances at Jobs Australia of employers facing the problem of individual employees setting up in competition with their employer and taking on support services for individual clients. So that's a new tension in the mix, the competition from your own staff. But I guess more broadly, the real competition is from other providers and other sectors which are facing the same sort of labour market constraints that you are, an ageing workforce, a need to rapidly create a new workforce, and that's true across health and community services and particularly aged care. So all these things are happening at the same time, and we're all having to develop from the same pool of the Australian community. One thing that struck me in terms of the workforce development work that's being done is the need for education, because it seems to me that there is clearly a role for both the NDIA and the disability services sector generally to really educate themselves and the public and people with a disability and their families around the minimum standards framework that we have in Australia around employment. Because many of the scare stories or horror stories I hear about are around people offering their services cheaply. We heard from the Workforce Council about concerns around OH&S, all those basic things about minimum award compliance, minimum pay rates, minimum occupational health and safety standards. They will all continue to apply into the future, no matter who the employer is. But I think there is a large gap there in the community generally about what are the obligations of employment and how are we going to ensure that they're enforced into the future. I also would encourage any of you who've got comments to make or questions to ask to please do so, and I'm going to ask my colleagues at the front table to take the microphones around if people want to have something to say, because industrial relations generally is a fairly dry area, and so if you've got a burning issue that you want to discuss, please raise your hand and discuss it as we go rather than wait towards the end. The issue of flexibility is twofold, or maybe three. When we're talking about flexibility in the workplace, it really depends on who is talking. What flexibility do your employees require from the workplace? What flexibility do the people with disability who are your clients require? And what constraints does that put upon you as the employer in trying to match those two concerns? Obviously, for most employees, they want and I say most here because it's a generalisation, they want reasonably predictable work within reasonable limits. They want to have job security. They want to be able to develop some sort of career path. They want to get satisfaction from the workplace. They want to go and develop their skills. And they want to have the flexibility that they can achieve in terms of life-family balance. For people with a disability who now have more choice in the coming environment, they need the flexibility to be able to obtain services as they need it, not when the day program is running or the training program is running, or when you can find a support worker to do a home visit. And obviously the new system is pushing ahead to try and create greater choice for people with disability in setting their own agendas for when they want services, what sort of services they want, where they want them provided. So we're presuming that there will be a move away from centre-based work towards work in the community or in the home. And as employers, obviously you need to balance all those different needs. And sometimes you won't have, well, probably invariably you won't have a great amount of money to spend in developing it. So you're looking at developing a service where you can balance the needs of your employees to have a reasonably secure job and be able to work within reasonable constraints, and service users who have a care plan or needs for services that they haven't been able to access before, and they're coming to your organisation and requesting that you provide those services. I think in terms of how you differentiate yourself, it will be necessary for you to develop a sustainable service, and the areas of differentiation will be around your mission, your staff, the skills of your staff, the diversity of your staff. All those things will become more important, but at the end of the day, you will still be the employer, and it's necessary to keep in mind that there are legal constraints beyond which you can't move, no matter what the needs of the person with the disability or their family. And we've already had a few examples in the workshops as I've been going around about individuals requesting services that service providers have tried to meet, but the downside of meeting them has been to the sustainability or viability of their service. For example, we had one agency in a workshop where a family had requested that the two current support workers, accompany the family on their move from one state to another. This is probably an extreme example, but maybe you'll tell me whether it's not. And the circumstance was that the family advised the service provider that they were moving to Bendigo, and they were requesting that the two support workers accompany them to Bendigo, fly them in twice a week. Unfortunately, that member did agree to that. I'm not sure how long the package lasted, but I guess these are the sorts of tensions that you're dealing with already if you're dealing with individualised packages. And there will be expectations coming from families and people with disabilities that it won't be possible to meet, or it won't be possible to meet it within the constraints of the law or in providing a financially viable service. Have other people had those tensions already in their workplaces? Yes, there's someone nodding up here. And did you provide the service?
We're under negotiation at the moment. The request is that the client's driven for their entertainment for 5 hours on the days that the service is provided. And at this point in time, the family has said, we'll subsidise whatever the costs are to drive this client just for 5 hours, 3 days a week. Wherever you take them, just leave them in the car and drive them. So that's the request.
And it's not a service you normally provide?
No, not for that.
And is it a service that you're thinking that you might meet?
I find that that's unsustainable.
Mm.
We haven't started yet, but we're...
Any other examples? No one's flying to Bendigo here today, I hope.
Caroline, I think one of the areas that we really struggle with, because it's actually legitimate, you know, and supportive kind of thing, is extended when clients want to go away on vacations and things and need support staff, and it's obvious, you know, to their benefit that they have people who know how to deliver their care plans. That's definitely, at the moment, you know, that's gone out of our capacity basically. So yeah, I think for us that's been a real loss of flexibility.
Because you don't have the staff to do it, or it's too expensive?
Expensive to do it within the award. You would need to send, if you were going hundreds of kilometres away, you're not having people driving backwards and forwards, you'd have to spend 3 hours to do a 24-hour roster. So it's just simply, yeah.
Yes, and the agency that was raising the issue of flying their staff to Bendigo, obviously the other participants in the workshop turned to them and said, you know, what about your linkages with other disability organisations in Bendigo? And so the conversation went, and people had quite a long discussion about holidays and replacing staff and the need to have a team that the family and person with a disability were happy with, and building a sort of a deeper workforce so you can meet those ongoing needs, but not always with the same person. But yours was actually an issue of cost around travel. Yeah. We've actually had some members who have arranged overseas holidays with support workers. That was a bit of a conundrum for the industrial relations team, trying to work out what the conditions might be in Thailand. We don't have too many of those, but more along the lines that you've suggested, where there's lengthy travel, or it's not a service that you would normally provide, but the person is requesting it. You're not convinced that it necessarily has value, but who are you to judge? The comment coming from most participants in the workshop where the Bendigo example was raised was around the viability of the individual person's package if they were to really purchase whatever they wanted straight up without thinking of how long that package would last. And I guess that's the other area of education, apart from employers being aware of, and this can include the person with disability or their families, being aware of their obligations as an employer and what limits there are on that, but also being aware about what sort of services might cost, and being able to actually make their own funds last longer. So I guess there's a balancing of a whole lot of people's expectations in this business, the expectations of the family, the person with the disability, your employees, and your sense of mission about what you think that you're actually going to provide to the person. And I have heard many participants in the workshops comment that they've found it quite confronting to find that the person with the disability or their family actually isn't interested in the services that they're suggesting. They want something else, which you don't currently provide, and you put in the situation of, do you actually develop that program, or is it something that really you can never seek to do in a viable way? So I guess you've all got a lot of different business ideas that you're pursuing, but the main driver to me does seem to be cost within the parameters of the current industrial relations framework. So we'll just diverge to the awards system to talk about what's happening now with the awards. You'll all be aware that there was, all the 4,000 awards that existed in Australia disappeared in 2010, and they were replaced by 110. So that was a significant change, and I'll hear from you all about what those changes meant to your particular form of operation. But clearly, because we moved from 4,000 different awards to 100 odd, all of those employees and employers who were formerly under those pre-reform awards have had significant changes, because not all of those awards have been picked up in the modern award. For example, under the Social Community Home Care and Disability Services Industry Award, which I'll call SCADS, not sure what the rest of you call it, there were 47 old awards underlying that. So if you're wondering why sections of the Queensland Disability Services Award or the Queensland SACS Award were not picked up, it's because you were competing with the 47 other awards, and there were parameters for what could go into modern awards. Modern awards are actually much shorter than the old awards, because now we have national employment standards in Australia which apply to all employees whether they're covered by an award or not. So we've got a lot more employees in Australia covered by our employment laws, because in the past, unless a union could track down an individual employer, serve a piece of paper on them, go to the tribunal, have that piece of paper enforced against them, an award was made, then many employees would be award free. So the introduction of the National Employment Standards, which is mainly leave conditions, and the modern award system has meant that all Australian employees are covered by at least the National Employment Standards, and then it's quite likely they'll also be covered by an industry award. And I'll just check now as to which awards we're talking about. For the purposes of my discussion today, I'm interested in the SCADS award, but I'm aware that as a practitioner, I was hopeful that the modern award system would reduce the number of awards operating in my members' workplaces. Hasn't happened. So I'll just check which awards are actually operating in your workplaces still. So can I have an indication, how many of you are covered by the SCADS award? So that's most of the room. What about the Labour Market Assistance Award? A few. And Children's Services Award? We did have a few in some of the other workshops, but not so many today. One of the Education Services Awards? A smattering. The Supported Employment Award? A few. Any other awards applying in your workplaces? If you've got it's your own enterprise award? Right, okay. There's a process going on at the moment in Fair Work to review enterprise awards, which were another type of workplace-focused award. Most of them looked fairly similar to one of the existing awards. Did yours look like the SACS Award or the Disability Services Award? Or was it quite different?
I think it's like the SACS award.
Look like SACS? Yeah.
Ours is disability.
Disability Services?
It was written against DWS.
But you had an enterprise award. Actually, is your enterprise award still in force? Because a number of them were extinguished in September last year.
No, it finishes September this year, November this year.
Right, okay. So they're still operating. How many people would also have enterprise agreements? Well, that's quite a significant number. We'll talk about enterprise agreements after afternoon tea, but the community sector generally has not been an area where there have been many enterprise agreements, and if they do exist, they generally have fairly low pay rates. But I think it will be a tool that employers use increasingly in the sector to sort of ensure that there are sort of common conditions in a way to, it's another way of coping with the issue of competition, to make yourselves an employer of choice. So that diversion was about really focusing on the fact that there are now a lot fewer awards, but in the community sector broadly, there's still half a dozen of awards still operating. Of course, if you have an enterprise agreement, it will override the relevant industry award, and you won't need to worry about many of the things we'll be discussing this afternoon, although you may have other worries about the enterprise agreement that you're currently under. So there were 47 main awards which have been replaced in the Modern SCADS Award, and it has involved major changes for employers, largely around hours of work, because the hours of work clauses in all those 47 awards were very different to what the current SCADS award is. And there's been the introduction of minimum engagements for casual staff, the introduction of longer breaks between shifts, changes to the sleepover provisions, and this has caused a fair bit of confusion and concern in services, particularly those that ran respite services or some type of shift work service. And I guess increasingly the disability services sector will be concerned around the issues of hours of work, but we've had many disputes and quite a bit of concern expressed from the sector around those hours of work changes to the Modern Award. Has anyone here been involved in a dispute around hours of work under the Modern Award? That's good. We have had some disputes in Queensland around hours of work and the Modern Award. And I guess the other major issue around the SCADS Award has been the introduction of the Equal Remuneration Order, which is the outcome of a major case run by the Australian Services Union, which resulted in quite substantial pay rises to the SCADS Award for SACS workers and crisis assistance workers. It doesn't apply to the other two areas covered by the SCADS Award, that's home care employees and family daycare employees, not because they're not deserving and not because they wouldn't have been able to mount just as significant a case, but because we've come from a system where historically a union would have ownership of their own awards. This case was run by the Australian Services Union, who was representing SACS employees, not home care, which belonged to another union, and not family daycare, which belonged to another union. So it really is just an historical anomaly that the Equal Remuneration Order doesn't apply to the whole award. It only applies to social and community services workers, but of course that does include disability services. So that's been a major challenge for the sector. And the other issues of transition under the Modern Award have presented other challenges. I guess you've all seen the news today that the national wage case, the annual wage review, Fair Work has awarded a 3% increase to all award pay rates from the first full pay period after the 1st of July. For those of you who employ workers who are entitled to the Equal Remuneration Order, you will in addition have to pay the relevant ERO increase in December this year and every December until 2020. I'm not sure that I'll still be interested in the pay rates in 2020, but it obviously was put over that period of time so that employers could accommodate themselves to meeting that increased cost. So that's the issue of the Modern Awards, and I've touched on some issues where the changes have meant operational changes for you. In the overall context of the industrial relations framework, we do have other legislation which affects your workplaces, and I think it's particularly important not just to focus on the award system when thinking about these changed workplace relationships, but also to consider the other legislation like the Independent Contractors Act, the anti-discrimination legislation and the superannuation, because obviously all employers, whether they're service providers such as yourselves or whether they're individuals or families employing people directly, they do need to be familiar with the whole legal framework of employment, which will be interesting. The issue of anti-discrimination law has already come up in a number of the workshops because, of course, clients now have choice. And I did hear the issue of ethnicity raised this morning in terms of developing a more diverse workforce so that you can match more appropriately clients' requests to have people from their same ethnicity or not, depending on how they feel about it. That has become an issue of choice for the person with the disability, but a concern for employers about how are we upholding discrimination law in this circumstance. Another issue is superannuation, and superannuation contributions by employers are about to rise to 9.5% of gross wages from the 1st of July this year. And then the government has announced there will be a pause. So as to whether that contribution rate continues to rise or not, we don't know, but the current announcement by the government is that there will be a pause in rising contributions until, I think it's 2018. So just as we began to increase superannuation contributions to a level where they could support workers in their retirement, we've stopped again. So Paul Keating's initial idea of a 15% contribution is still a long way off. The point I want to make about this legislation, I should also mention workers' compensation legislation, because I think that is a particular concern that was mentioned this morning. All these laws obviously apply not just to yourselves as employers, but to the families and individuals who will be directly engaging employees in the future. So in one sense, that does develop a level playing field with minimum standards of employment and a minimum pay rate, which applies to all employers engaging staff in the industry. But there is a major challenge for you, for the sector, for the National Disability Agency in actually filling that gulf in understanding about those obligations at the moment. At the moment, the Fair Work Ombudsman has the obligation to educate the Australian community about their obligations as employers and employees. This is a particular sector where I am aware that they will be working with the disability sector to talk about how they can develop materials to assist individuals who are moving into becoming employers. And I'm aware that some of the workers' compensation agencies are also developing training to assist individuals with disability or their families who are engaging staff directly. But I think we did hear early this morning the concern expressed from the sector about how can you actually supervise staff appropriately in the home, how can you ensure that the OH&S obligations are met, how do you convince the individual family or person with a disability that this is an important issue. So I'm aware that a whole lot of government agencies are looking at that question, but as to how far that education is going to go, we don't know, and obviously you're dealing with some of those issues already if you're taking on responsibility for employees who have been engaged by families or by individuals. Do many people here currently take on the employment responsibility for employees on behalf of a family? Yes. What's your arrangement?
At the moment, it's actually a family-driven program that we have. So the employees are completely our employees, but they're recruited by families. So, and for us, you know, extremely challenging for all the reasons you listed. At the moment, we're taking very much a cooperative approach because a lot of the families haven't been engaged with paid supports before now. So it's really about, but it's really resource heavy, educating families about workplace health and safety. We take care of all of the, you know, the financial obligations and the board issues and things like that. But really for us, it's around risk management, around workplace health and safety.
And do you participate in the recruitment, or do they come with the person already employed?
We employ the person, but they recruit them. So it will be someone they know, maybe someone who's suitably qualified and experienced in our eyes, and who we would employ if they, you know, responded to a job advertisement. Or it may be someone from their informal support network, not a family member, but someone from their informal support network who they identify as having the right values, and then we've got, you know, training and all sorts of things to put in place.
And do you ever refuse to take on that person?
We have not as yet. We certainly reserve the right. If we certainly around workplace health and safety, that's probably one of the areas that we'd be most concerned about. So if there was a reason to think that the person wasn't physically suited to the position, or there were other areas of concern around skills and capacity.
Because some of the previous workshops that I've run, people have talked a lot about the need to engage new staff and how that's challenged by the fact that the person has come through the informal networks and has been employed by the family. And also, at what point does the organisation decide that this person's not a good fit for our organisation and we won't actually take them on because the risks are too great, or you can't envisage that you could train the person to fit the other criteria of your organisation. And do you have any contractual arrangements with the individual to keep them in the workplace if that family disengages them?
It's an entirely casual workforce.
Right. So around those particular arrangements, you would keep it casual because of those challenges of fit.
Absolutely, and I mean, quite often it's not only just, it may well be a regional, we've got rural and remote families that are doing that as well, so simply our capacity to provide work beyond that single arrangement would not exist.
Does anyone else engage employees? Yes.
Yeah, well, we do it in a similar manner, but we just take a little bit more control around it in that families don't actually employ them. We're saying that we employ them, but the families, all the individualised funding, very much part of the interview process. They actually ask their own questions, they write their own, in addition to our standard questions. They're really part of the reference checking, and we get a result on that. But the employee themselves are actually contracted to that individual, so if the family decides they don't want to keep them on anymore or moves or whatever it is, their contract hours are gone.
So are they casual or are they on minimum hours?
They're permanent employees, they're contracted specifically, so they might have 10 hours with Jane, 15 hours with Bob, and that, so, and they're very rare that the contract says that, but if they could lose their hours. Sometimes the family, or more likely the person themselves, occasionally, it happens more often than we'd like, for whatever reason, says quite vocally that they don't wish to have that person supported anymore. And that's the end of those contracted hours. They keep the rest for the rest of it. And naturally, we work to find more work.
Yes.
But that's very much irrelevant. And that way, the individual retains the power and the family in that sense. But the actual recruitment is done collaboratively with the family. It's very successful.
And do you have the same concerns as your colleague over here about how resource intense that process is?
Actually, no, I don't find that too resource intense. I do have, but mostly because yours are actually kids are coming from the probably very close to the
Oh, I think it's quite a different process. Yeah.
Whereas we're still going to the open job market and actually just improving it. But they're quite specific about what they want. And sometimes they come back to the second year and bring the actual person with disability course and not be part of it and leads them. But in that sense, we control it in as much a collaborative manner as we can. Professional boundaries is a real issue we've got to try to get rid of that. That was a real issue.
And have you had instances where you've had to discipline the person? Or
That will happen, that can happen in every
Yes.
Not because they necessarily had prior connection with the family, but because if they remain with one individual for a long time, they can actually simply become too entrenched by their own. So sometimes you do that.
Yes.
Can I ask you a question?
Yes.
It's really about that. It's probably more Shelley too.
Don't ask me stuff.
No, it is, because I've seen it on a few documents. I've seen those figures around 13,000 employees now, and in 2018, I think they quote 26,000. And I wondered to myself, where are they getting that from? And then, not to say that it's necessarily your fault, but you said there's a presumption that there'll be a move away from centre-based activities, centre-based support, to individual support. Is that what that figure's based on? Is that where you're doubling the workforce because you think of that?
I don't know. Can NDS assist me here?
Within Queensland, the expectation is that 97,000 people will receive support under NDIS. That's the government's figure. At the present time, under the specialist disability service areas, the number is about 27,000. Now, in other areas like HAC and other forms of, or other programs, that number moves up to probably around the 56,000. So we've still got to get to 97,000 at least. And that doesn't take into account the huge population growth that's going to occur in Queensland over the next 20 years, where the total population of the state at present in 2031 will be living in southeast Queensland. So you've got huge issues in terms not only of the transition to the scheme itself, but dealing with additional demand through population growth. That I don't know the exact figures, but that's why it's doubled, because there's an expectation of a doubling of service provision. So it could be more than that, but you know, that's a fair indication, I guess.
I know certainly the feedback from the trials has been that there's a lot more unmet demand than was ever imagined, that a lot more people would be eligible than the original thinking was. So obviously there's a lot more people that need services, and I'm sure we know those people already, that there is a great amount of unmet need out there. So the challenge will be to find that workforce in with an ageing population. Yes.
It's actually not a question, it's a comment.
Yes.
The issue about the move away from centre-based services is based on the experience elsewhere in the world where there's been a move to individualised funding and self-directed and self-managed funding. Given the choice about the use of the dollars, apparently most people don't choose to purchase a congregate service but to pursue their own individual goals or interests.
I get that they want to do that. I just argue that they won't go forward to do that. I'm sure everybody wants.
Yes, I think there is still a lot of expectation management to come. But I guess that's what the trial's about, finding out what actually is viable. And that's what you're all currently involved in, trying to work out what actually you can offer in the future and what will be viable to continue to offer. So I think there's no doubt there will be a need for a bigger workforce. I think where the unknowns comes in as to what will that workforce be doing, where will we get them from, how will we upskill them, all those sorts of issues. Any other experiences that people would wish to share?
Another comment, if you don't mind.
No, go.
You talked about the expectation of families before, and here's one example a service provider gave me where they had a individual package for a person, and they said to the provider, you're the one that we want to deliver this package, but we want you to employ the support worker at level 1.1. So, you know, that's the sort of thing that potentially could be something that you have to deal with. And of course, this employer said, well, my employees have rights under the award, and there's an expectation that they'll be paid appropriately. But the person or the family went to another provider and they said yes. So that sort of thing is potentially coming your way as well, the expectations of families, so that their package goes further.
Yes.
I stand by your life, your choice thinking and ideology, and even if that's old thought now, I don't know. But there's going to have to be some sort of discussion and talk, like in real terms, from maybe government level, of what are we going to do to put insurances there for workers, because there's got to be a reasonable framework for it to work. Otherwise, it's not going to be practical. People will go to all sorts of jobs because there's not the sort of job security environment that they might be needing. Like, you always need a casual force. You're always going to need that in whatever sector you're dealing with. But there's a certain amount of your people who are going to go, hey, I've got families, I've got a house I'm paying off, and if you want me to study and get qualifications that take years to get, where are you going to stand by me?
Yes.
I think that's a very real perception among the workers, at least. And there's a lot of workers I'm talking to, not in our company, but I know a lot of people. And a lot of those people, probably 70%, I would say, like that'd be my estimation, of the people are saying, I'm going to resource work somewhere else because this is all too uncertain for me. So
Because it already appears to the employees that it's becoming a more uncertain way of working.
Yeah, and I think some maybe not all of them, but a lot of services are kind of spooked in the regard of because they've got budgets to meet and all this sort of constraints. They're looking at, so you get the response of, we're only going to hire casual people because of all this stuff going on. And so there needs to be, I think, talk and discussion around that, as well as the discussions of how we're going to provide a better service and meet the needs of people with disabilities in a better fashion. But it also comes back to the people who are looking after those individuals. We need to look after them as well, I think.
Yes. Yes, the person in the front.
Thank you. I am a mother of 2 young adults with intellectual disabilities. I feel that the government needs to educate the families. I'm also with a small service provider. I feel the government needs to educate the families, first and foremost, and teach them what they can get for their money and how that they need to be able to, the organisations need to follow rules and regulations and make sure that the staff are well protected. And I think that comes from education, the families more, and the person with a disability, more than anything else. We know what it's all about, but the families out there, this is money that we used to have individualised funding, which was great. Now it's going back, now we're going further ahead, but I really think that families need the education.
Yeah, I think that's a very valid point. Anyone else want to comment on that issue? Yes.
Hi, I'm just aware in rural and remote communities where personal care support is very scarce, where people have had individualised fundings, they've actually got the person to register as a business, so they had their own ABN and responsible for their own super and so forth, and then they just contracted those people, so they directly paid the people. Their support workers actually became their own business.
Yes, and we've had reports from some of the workshops through NDS that's happening already. I think the whole issue of regional and remote communities and the challenges they face is probably a whole other workshop, because I agree with you, it is very difficult to imagine how we can get services into those areas. There's already so much they're missing out on, even telecommunications, it's very difficult. But just in general, there has been a move by some employees to set up with their own ABNs, and service providers have reported that they've persuaded their clients to move down the road and use their business, their personal services, rather than the community agency that they were formerly using. I think that is a marginal risk, that individuals will see that they can make a living from providing their own personal exertion and setting up their own businesses. But I don't see it as a particularly common way of engaging people to provide services under the NDIS, because as soon as you get past the individuals just being a husband and wife or two sisters or whatever, whoever's running the business, as soon as they start employing other staff, they're caught by the safety net just like you are. So there's a limit to how much individuals can subvert the safety net that you're talking about. I think the whole issue of insecurity is a very big one. Maybe we might ask the audience now, how many of you have a predominantly ongoing workforce? Does anyone have a completely or 80% casualised workforce? And is that because of the types of services that you provide? So is it all, what's the nature of that insecurity or?
It's the timing of the services that are required, in that they're predominantly either early morning or late afternoon into the evening. So we find that we have staff that will work the mornings and then go on to other jobs, students that will work the evenings and they're studying during the day. So yes, our workforce is predominantly more than 80% casual. The only permanent full-time or part-time staff we have are administrators.
Right, so just those core staff that run the business. Anyone else put up their hand to say they had a casualised workforce? Yes, what type of work do you run?
Recreation support, so the employees hired in relation to the best fit for the individual and what they're.
We're a recreation organisation, so the employee is hired fairly specifically for the needs of that individual and the time frames that they've requested to go out and activities that they've requested to participate in.
So it's more like casual work. It comes, it goes, people go to discrete events and that is it for that week.
It depends on the nature of what it's quite varied for each person, I have to admit. Yeah. So it may only be fortnightly, it may be weekly. The person might go out with 3 different people in the course of the week.
So could you build such a scale that you could have an ongoing workforce if it was large enough and you had enough clients?
Yeah, you'd have to maybe, if the agency was maybe 3 times the size maybe, there might be some scope there, but you also have, person's needs and interests change, so that's a consideration as well.
Yes, I'm interested to see that you've got casual staff who obviously it suits their time of life. Like we've not got the issue, maybe it's a life cycle thing. There may be people who are happy to work casually while they're studying or young. When they get commitments, we all want a more secure lifestyle. Do you mainly employ students?
Very both ends of the spectrum, nothing in the middle. So we have predominantly either students or mature age people.
Or mature age people that their family are, they're, what do you call them? Empty nesters.
Yep.
Yeah. So it's their 3rd or 4th career or their final career, come back into the caring industry. So that group in the middle, we have very few of the where your charts that showed the 25 to 45 age group, we have very few in that age group.
And I think that's what the demographics show too, that at each end of the working cycle, people are more likely to be engaged in casual or very part-time work. But I guess the challenge for all of you is how can you have a diverse workforce with a mix, or maybe there will always be some sorts of services which always will only attract one type of worker.
I think you've got to come to a certain acceptance if the type of work you're doing, that's what the type of staff that are attracted to that work. And I guess it's an acceptance of that's what the profile is. So you need to work around that. And then you have the challenges if there are staff that come in as carers that want more permanent work, they'll tend to go to services or organisations that have long day respite or sleepovers, supported accommodation. And that
They'll go to other organisations.
They'll go to other organisations, yeah.
And your service plans to keep its business model based around that casual type of engagement?
not in the long term. I think as the evolution of the NDIS happens, we'll find that there'll be probably a change in that, because with the block funding of some of the programs that are around, people have no choice but to go to, for example, a day respite centre. That's it. They have not the option of choosing to have some alternatives. So there may be then some alternatives for staff to have longer shifts, more hours, because the individuals will choose alternatives to those.
That's interesting. What about the rest of the audience? Do you basically have particular types of your service where you would have a casualised workforce?
We have a passion from an organisation that basically we employ it and use them as fill-in staff. So they do they're just our fill-in staff who use casuals for that. But some individuals, this is the interesting challenge for us that I've seen, some family members and the individuals themselves are telling me they actually don't want a permanent arrangement with a support worker. They actually want casual, and they're prepared to pay the higher rate for it, because just like you or I, they don't want to have their whole week scoped to 2 o'clock on Wednesday, or they want to be able to ring up each day and say, I'd like to have my hair cut tonight, can I have someone from 6 till 7? And that's, to me, that's one of the biggest challenges we'll get. We need a combination.
Yes, I was thinking when you were talking about your employee characteristics, I was thinking it's really just like me going to hire a personal trainer, who invariably are young people doing education, and they work early and late to meet with their own life needs. Yes, it's interesting. Okay, well, we'll move on to the industrial landscape and how it's changing at the moment, just to give you an opportunity before we finish this part of the session to feed in your ideas about what needs to happen to the awards system. Because this was a new industrial relations system, and I think the previous government did hesitate before they actually continued the life of awards in the Australian workforce. They built in a number of review steps so that what was quite a major change could be reviewed and then reviewed again. Now we've got a change in government as well, so we're wondering if there will be some changes to the Fair Work Act, although they have indicated there will only be marginal changes around the edges at this stage. So we have the Fair Work Australia reviewing all the awards at the moment. We've come through the 2012 review, which was a technical review after 2 years of having a new award system. And some of the issues that were raised in that review are still unresolved and are likely to be revisited again in the 2014 review, which is a major review. And some of those issues are issues which were causing disputes before the review and are still causing disputes after the review, because clearly the industrial parties or some employers do not agree with the way that the award is worded. So now we have, earlier this year, the Fair Work Commission commenced reviewing all of the modern awards, and there's a timetable to review those awards going into next year, which anyone is entitled to participate in, from just putting in a submission to actually, appearing before Fair Work. And that was true with the 2012 review as well. And I have to confess, it's been a bit annoying to me, because I've worked in industrial relations for a long time as one of the industrial parties, either for a union or an employer association. But now individuals can put in their views about an award or a clause in an award, and Fair Work will take that submission seriously and look at it. So we have had individuals. But there was a woman from Queensland who wrote to Fair Work and didn't agree with the operation of, I think it was the sleepover clause. So that's was back in 2010, so there was a review around that clause back then because an individual was not happy with the operation of the award. And whilst it's still true to say that it's mainly the industrial parties, the unions or your employer association, which is putting forward their views to Fair Work, it is possible for your organisation to put in a submission. And obviously I'm here today because NDS is interested in putting in a submission to Fair Work, and Jobs Australia will be putting in submissions on behalf of a number of our members as well. So the whole award system is being reviewed, and at the moment Fair Work is getting organised with the administration, I suppose you could say. There are some common issues to all awards which are being reviewed at the moment, and then they'll move through each individual award, award by award. So the outcome of those reviews can be changes to the award or no change, depending on whether Fair Work is convinced. So that's what I'll be seeking your views about just before the break. The other thing which is changing with the award is obviously the implementation of the Equal Remuneration Order, and that process will go through till 2020. I don't know whether people have experienced particular issues with that process, apart from meeting the wage rates, I mean. Have people struggled to find out what the correct rates are? Because I think that's one of the issues. And in fact, Fair Work doesn't produce pay rates for the SACS employees under the SCADS award. They have a calculator. And a number of employer associations, such as my own, do produce pay rates, but it's a fairly vexed business. It does seem unusual that it's so difficult to produce a pay rate. But that's because we're still in transition from the old 47 underlying awards, and put on top of that we've got the Equal Remuneration Order as well. So that no employee can be worse off, that process continues. The other transition under the modern awards is the transition from the loadings in awards. So pay rates and loadings are meant to be fully transited into the modern award by July this year. And for every other award that you'll deal with, that's true. And for loadings, that is now true. So in July, there'll only be one rate applicable to the various loadings in the award. There won't be any phasing in of loadings going on anymore. But in terms of transitional pay rates, that's obviously going to continue for quite a bit longer under the SCADS award. No one's had any disputes about the pay rates? Under the Modern Award Review in 2012, the issues which were reviewed were the sleepover clause, where there was a minor change but not a major change. Shift breaks were reviewed, but there was no change. The definition of SACS employees was slightly altered. And then in August last year, there was a provision inserted into the SCADS award providing more clarity about what information you had to provide employees who were part-time, ongoing part-time employees. And that's now in the award. And more recently, in March this year, there's been a decision of Fair Work to reinstate, well, for some states and territories it was reinstating, for others maybe not, penalty rates for casuals on weekends and inserting overtime provisions for casuals. So the modern SCADS award didn't include any overtime provisions for casual staff, and it didn't include penalty rates on weekends for casual staff. It now includes both, so casuals have either got those conditions back, if that's the way you wish to see it, or they've got new benefits which they didn't have before. Listening to our members, it seemed to me that if an organisation was previously paying loadings for weekends, they couldn't really move away from that in terms of the market. If you wanted to have casual staff work on weekends, most of my members retained those penalties. What did you do here in Queensland? Did people drop the penalty rates for casuals on weekends, or was it just business as usual? I think that was fairly commonly the case, but I guess there was some providers who actually did drop down, and so now they're facing the prospect of reintroducing penalty rates on weekends and are finding they can no longer afford it because they've changed their business model in the meantime over the last 4 years. So I won't be surprised if all of those issues come back again, but there was a suite of clauses which Fair Work looked at in 2012, and they only picked up those few. So now we're having the 2014 review, and we're starting with common conditions affecting all awards. And the sorts of common conditions that Fair Work is looking at is annual leave, and that's to do with whether awards or agreements should be able to cash out annual leave, or whether an employer can manage annual leave which has accumulated to an excessive balance, whether they can require their employees to reduce their leave or be directed to take that leave. I always laugh on the issue of annual leave because it's my experience it will be the people in the room here today who have excessive leave balances, not your support staff. It's usually an issue of a board member ringing me about the CEO, or the CEO ringing me about their accountant. It's usually to do with managers being too busy and not applying the same rules to their own leave as they do to their staff. But for what it's worth, the National Employment Standards allows employers to manage annual leave and to require staff to take it. It also allows employers to have an annual close down with certain notice provisions, but none of those provisions are actually inserted in the SCADS award, which really means you could do it, but only if it was in an enterprise agreement. And so many of you will have enterprise agreements which allow Christmas close down or school holiday close down, whatever you have, and allow you to manage staff's excessive annual leave balances. But those sorts of clauses only exist in enterprise agreements. They're not inserted in any modern award. So Fair Work's going to review that issue. Because there's been a reluctance in Australia for public policy reasons to move away from leave, which is obviously a hard-fought union condition. And I guess the concern of unions is that employers will roll up annual leave in pay rates so people will work continuously and not take any leave. Obviously the current law doesn't allow that. People have to still have a month's pay in reserve at any given time. If they are allowed to cash it out, it has to be in excess of that. But that's the issue that Fair Work is looking at now. In July this year, Fair Work's going to look at the other transitional provisions under the Fair Work Act. So in some states and territories, there has been provision for accident make-up pay. So if someone's away on workers' compensation payments and invariably they drop down over a certain number of weeks and months, the employer is obliged to top up the pay of those injured workers. And that entitlement has been preserved in the Fair Work Act, but it had a sunset clause of 2014 December 2014, so that's being reviewed now as to whether it should continue or not. I can't recall whether the SACS Queensland Award had accident make-up pay. Can anyone here tell me whether you ever had it in Queensland? I think it's mainly a Victorian condition. I have to say that Victorians, who I work with most commonly, feel quite aggrieved by the modern award system because employees lost a lot of conditions, because there were a lot more generous conditions, like accident make-up pay, like the small employer redundancy provision, like 21 days of sick leave, those sorts of things. So in Queensland, you haven't had that to deal with, so as you can imagine, employers are not all that happy with those provisions. And invariably in enterprise bargaining, they try to reduce those conditions, but that's quite a hard ask. So I can see Queensland's not one of the states that will be affected by this particular issue. So accident make-up pay, I think you were affected by the district allowances, because Western Australia and Queensland, the Northern Territory, various allowances were provided to employees for travel, basically. If I can't remember which latitude it was, but the latitude is actually stated in the award. So if you are required to work further north, does anyone know what that latitude is? I think it's north of Townsville, but I'm not quite sure how far. And so Fair Work's reviewing that because, again, it has a timeline. And my Western Australian members are keen to see whether they're still required to pay district allowances for people in the Kimberley or Broome. And redundancy provisions varied from state to state before the Fair Work Act. So again, that's another common condition that Fair Work is looking at in all awards. And the current provision in the National Employment Standards is that employers who employ 15 or more staff are required to pay severance pay as well as notice to their employees, and it's on a sliding scale according to service. But if you're a smaller employer, you are required to consult with your staff and to give them notice if you're retrenching them, but you're not required to pay them severance pay. So that's being revisited by the unions because in a number of states, including Queensland, there was a small employer redundancy clause which said that you could pay your employees severance pay but on a reduced scale. So that was 4 weeks to 6 weeks, not 4 weeks to 16 weeks as larger employers are required to pay. So that's being reviewed. And I hadn't really considered getting people's views about those common conditions, but obviously when we break to talk about changes to the modern awards, you're certainly welcome to talk about those issues as well if they affect you. I'm presuming they won't be continued after this year, but maybe they will, I don't know. A lot will depend on what the Commonwealth Government submits to Fair Work, because obviously a change of government means that different submissions are made by government to Fair Work, and they are a major player in industrial relations still. In September this year, Fair Work's going to look at the conditions that part-time staff versus casual staff have, and that's around giving more conditions to casual staff and, in some ways, more conditions to part-time staff. So the unions are looking at minimum engagements for part-time staff. Currently, you're obliged to employ casual staff on minimum engagements. So it's either 1 hour, 2 hours or 3 hours, depending on whether it's a home care service, a disability service or a SACS service. The unions plural have applied to extend those provisions to part-time staff. And I do often have queries from you all about what's the minimum number of hours I can employ a part-time member of staff. And I invariably say there isn't one. There were in the previous awards some minimum provisions in the New South Wales Clerks Award was 2 days a week. but it hasn't been very common that part-time ongoing staff have had minimum engagement. So that's one area that Fair Work's looking at. The union's also looking at increasing the penalty for workers working on broken shifts. So a few issues around extra entitlements for casual and part-time staff. So obviously that will have an effect on this sector if you employ a lot of casual or part-time staff, because in one sense the price is going up. Taking into account the issues that you raised about, is it fair that these workers suffer from job insecurity, and are they going to be attracted to other areas if we become a more casualised industry and have fewer rights for part-time staff? And the other two common issues that are being reviewed across all awards is the award flexibility clause, which I will talk about a bit more after the break, but that's basically a mandatory clause which is in all awards and all enterprise agreements, and it allows an employee and an employer to change some of the conditions of the award in a flexible way, so long as the employee is not worse off overall. And it's around 4 areas of employment. It's around hours of work, or the arrangements by which work will be performed. It's around overtime provisions, the use of allowances, and one other which escapes me. Oh, leave loading. The two latter ones, I don't really imagine that they're of much concern to people. I think most employers would be interested in maybe rolling up leave loading or allowances in a common rate of pay. So for that purpose you could do it. Some employers like to pay leave loading at Christmas, not when the person takes leave, but generally speaking I can't see much work for those two provisions to do. And mainly employers are interested in varying the hours of work clauses. Obviously you can do the same thing by using an enterprise agreement, but that's a whole lot more trouble, as we'll get into later. And it's also an area where staff often want to change their hours of work as well. When it overlaps with the issue of penalty rates, it's very unlikely that you'll be successful to get that up. I had a situation where an organisation was approached by a student who was running a youth group on Friday afternoons or Friday evening, I can't remember, and she had requested to move that youth group onto Saturday under a flexibility clause in the award, and the employer asked me whether they were able to do that, to agree to that. And after some discussion they decided not to go ahead. It was instigated by the employee. It looked like it was beneficial for her because she attended university on Fridays. Obviously her course had changed, so this term she was going to uni on Fridays. She wanted to swap her job to Saturday, but of course Saturday attracts a penalty loading for weekend work, and the employer decided that they wouldn't go ahead. Not only because it would be difficult to show that she was better off overall, but also because they didn't necessarily want to change their whole operations just for one term and to have the building running and all those operational reasons why you might not agree. But my concern was that Fair Work has really restricted the use of those clauses because they've said that financial considerations are the main consideration. So if the young woman was going to be paid less because she was working on Saturday, which would normally attract a penalty rate, then she wouldn't be better off overall, even though it suited her to change her hours. So there's real restrictions on those award flexibility clauses, and there's now a review of whether they should be eased up in a sense, so that you're able to take into account the operational needs of the employer and the non-monetary considerations for the employee, because obviously that young woman who was a student really didn't want to work on Fridays. It was of benefit to her, but we couldn't say for sure that Fair Work would see it that way. So there is pressure to change those clauses to put non-financial benefits into that clause so that it works a bit more easily. And the whole issue of loadings, you will see from the press, is being reviewed, whether penalty loadings should exist at the rate that they are now, whether there should be a reduction across the board or award by award, and again, whether public holidays should attract the loadings that they currently have. So that's the common applying to every modern award review that's going on in Fair Work. And then later on this year, they're looking at the SCADS award along with a whole lot of other awards. It's being reviewed for its specific terms. So you have two opportunities to put your perspective as an employer about what the awards should look like. So those sort of overall conditions, whether they should change. And then when it comes to the SCADS award, whether there are provisions in there which you want to see revisited. And at this stage, there's no submissions around the SCADS award. There's discussions from the union about revisiting some of the issues from 2012, like the small business redundancy provision, and issues around hours of work, like broken shifts and sleepovers, but no proposals have been lodged yet because none have been called for. The sort of areas that I think will be looked at again by employers will be the issue of hours of work, sleepovers, broken shifts, excursions, 24-hour care. Some of the provisions that are currently restricted to home care or disability services, there's a push by employers to broaden them out to other areas of work. And then there's the issue of sleepovers and penalty rates in general. So we might break now and do some work on your tables around some of these issues affecting the modern award. So what I want you to contemplate is the sorts of issues which are affecting you in the workplace around the area of the modern award. We'll have 10 minutes on our tables and then try and pull some of those issues together with a view to feeding that back into the submissions that NDS or Jobs Australia or you yourselves may wish to make to Fair Work around the modern award. Some of the other areas you might want to think about in reviewing the award are things like the minimum engagement for casual staff, the requirement to consult on changing rosters, the classification system, whether that works for you or not, the current loadings and penalty systems for shift work, casual work, weekend work, the hours of work, as in the span of hours in the modern SCADS award is 6 a.m. to 8 p.m. And staff don't incur overtime until they work outside those hours or attract a shift penalty. The shifts are 8 hours a day with a maximum of 10 hours. The breaks between shifts are a minimum of 10 hours between shifts. So all those sorts of provisions. Just think about what's been affecting your workplace and whether you can see any changes that could be put forward from the employer's perspective around all those issues. Now, maybe also you've found your own ways to work with those current award provisions, so I'd be interested to hear about those as well. So areas where you see the current award provisions act as an obstacle and changes you'd like to see. We'll come back in 10 minutes and I'll see what you've all come up with. Okay, can we just have, we'll have a selection of tables reporting back on issues you are affected by under the Modern Award. So Catherine's approaching that table. I'll just get her to ask someone there. What issues have you discussed? Yes, we've got someone who's prepared to speak. Ken.
The issue around overtime clause, the 10-hour break clause, what constitutes recall to duty, and more importantly then the broken shifts and how they all work in combination, because there is a case in Hervey Bay you may or may not be aware of.
Okay.
$4 million hindsight payroll adjustment on the 10-hour break issue went into liquidation.
Really?
Yep. And quite a few other organisations are facing similar things by misinterpretation of it. But and also what hours of duty. So the hours in themselves in the sense of minimal hours. 2 hours in the award for people under the disability side, 1 hour in the award for others. And if we're talking about an NDIS, 2 hours may or may not work because you may only get paid for 1 hour and you're paying for 2. So there's some of the major issues we're facing.
Yep, okay, that's good. It's most unfortunate the group that's gone broke. Okay, what other tables have had comments about the Modern Award?
Got issues? Who's got issues?
Lady over here.
It was just point out around the removal of the 820 hours minimum to move from one pay scale to the next, from one pay point to the next pay point, has impacted on some agencies in relation to having staff who only do, you know, two to 4, 2 to 6 hours in a week, moving up through the levels as quickly as somebody else who's done the 15 hours a week that's required.
Yes, you're talking about incremental progression, which under some old awards, it was possible for part-time staff to have to serve 2 years to get their increment, or 18 months, yes. Okay, yeah, I think that's an important point. Any other comments? What about this table here at the front? No? Sorry, that's all right. Any other Modern Award issues? Any comment on the common issues? No, we're all ready for afternoon tea. Okay, well, thanks everyone. I just want to keep you talking for a bit longer. So just to wrap up on the Modern Award issue, as expected, most of the comments were around the hours of work and how malleable they were under the Modern Award. And no doubt NDS and your employer association will be consulting with you all about what formal submissions you want your employer association or NDS to make on your behalf. But the SCADS award provisions under the Modern Award are not being reviewed until later this year, so you've got plenty of time to actually be consulted on it and put something together. Just want to make one point about the existence of the Modern Award, whatever its limitations. Because this is an award-reliant sector, there really is a level playing field for employers. The wages in the Modern Award basically provide a fixed price. Now, I know that there's a whole lot of issues around the NDIS and what price they're going to pay for services, which is different from wages, but not so different in our sector where wages are about 70% of your budget. So in a sense, it does provide some protection to employers from competition from other providers. I know that some of you have been talking about employees who've set up their own businesses or independent contractors entering the sector, but I still think whilst that happens in most deregulated environments, particularly at first when a sector becomes less regulated, there still will be the issue for those independent contractors as to whether their services will be viable going forward as well. And obviously, you've got a lot more to sell in terms of your services being quality-driven services with significant reputation, which you'll take forward with you into the new system. So I think just that point about the award system actually is a major protection in Australian society for employers against competitors as well as for employees. Now, in terms of where you want to move your organisations to in the future, we've had a bit of a brief discussion about what types of employees you'll need to have to meet demand in the future, and of course how you're going to attract enough staff to provide services. I'd now like you to, on each table, consider what characteristics you envisage that you will need to have a sustainable workforce. I'm mentioning both of those things as the characteristics you need in your workforce to make it a sustainable workforce in the coming NDIS environment, and what potential obstacles to employing workers in a way which will meet the needs of people in the new environment. What obstacles are there in the system right now? So if you can just speak amongst yourselves on tables for 10 minutes about those issues, and then we'll try and unpick some of them. Thank you. We've all considered what characteristics you're looking for a future sustainable workforce in the NDIS environment. What do people have to say about the types of characteristics? I've heard quite a few as I've gone round. What about this table? What sort of characteristics do you think you need to develop in your workforce?
Probably we need more flexibility and versatility in the workforce, so people being able to adapt to circumstances in the environment when they are out with consumers, because whoever it was that indicated that moving away from necessarily a centre-based setting into their own environment or their own community environment will require people that can think a little quicker on their feet.
They're more autonomous.
And whereas it's quite a controlled environment in centre-based care, for example. So you're probably needing people with more ability to think and risk manage their environment on their own.
Yep, good points. What about the table behind you?
We have flexibility as well.
Flexibility?
Our small organisation has been doing this for the last 15 years. We're very flexible. We've got flexible staff. They're wonderful. But we're small. I feel with the bigger organisations and the constraints that's put in against I think bigger organisations are going to have to look at themselves and be a lot more flexible than they are at the moment. It's important for the people we support to give them a quality of life in the community. It's important that we work with the families. As I've said earlier on, I think it's the families that are going to need a lot of training in understanding what the decisions that they're actually going to be making on behalf of their person with a disability, if with an intellectual disability. But I just think that flexibility is a really, really important thing.
And you're looking at your employees to sort of play a role in that expectation setting with families or people requesting the service?
Our employees do it as we speak. That's what that we've trained them through the years to do, because we are one-on-one in community. We have, accommodation support, but it's from staff coming in from other organisations, it takes a while to actually train them out in community, and giving them that flexibility, whereas they'd say, oh, well, we were never allowed to do that before. I said, well, this is different. This is how it should be, and you need to be flexible for the person that you're supporting, because that's why you're here.
So have you got specific induction programs or training to bring people into your
Yes, we do.
organisation's perspective?
Yes, we do. Yep.
Anyone else on that table? No? What about the table behind you, Catherine? We're going backwards.
We agreed with that. We also had down just making sure that the people actually fit the values of the organisation or the culture of the organisation as it moves to a different cultural environment. And
That you take your staff with you?
Yeah. Well, it's going to require some different skills or some different abilities, and you're going to have to change. But it also requires good management and responsive systems. So management's going to have to get used to letting things go. And
So management skills?
Yeah, that'll do.
Yeah, that's good.
We've got sort of more sort of characteristics that we're seeing in the future workforce. So resilience, adaptability, more of a business sense, creativity, keeping person-centred within the changes, customer-oriented, in newly turned, and then also manager and leadership skills around the sustainability and viability of organisations.
Other tables?
They want to do the next one.
Okay. And right at the back.
Do you have anything new?
Probably more quality training for the staff so that they're ready and they know what's going to happen for them. That was one of the main things that we were thinking about. Yeah.
Yeah, we discussed the same sort of thing around training opportunities and making sure that that people were trained across a whole variety of, I guess, a range of different skills, as well as the need for some really specialised, for people around having really specialised skills as well. So having that mix.
As well as that, we were saying that it's really important to have that ongoing supervision of staff, and how that's going to happen or be possible with the new system.
Are there other comments about the characteristics of the workforce? Yes. Catherine, just here.
I was mentioning, I have people with the award, it doesn't really take into account the differing support needs of people. I have people that the pay is probably fairly fitting, it's a good job, it's easy work, and I've got other people who've got very, very high support needs, need quite specialist staff, and they're competing against child safety and a different arena which is much more highly paid, and struggle to find quality workers with the depth of experience and knowledge that's required.
And is that an obstacle for your organisation because you can't compete on the wages?
Can't compete on the wages.
You can't recognise that extra skill base because you can't afford to?
Oh, absolutely. It's at the normal award rate, and there's very high level support work competing against nearly $10 an hour more in other areas.
So other parts of the industry,
in particular,
aged care or children's services, or
children's services, yeah, and youth work type, troubled youth work.
Yes, a gentleman over here was commenting that his staff are required to have specialist skills in meeting challenging behaviours. Do you want to make a comment?
Yes, we're an organisation based in Redlands who look after people with challenging behaviours and behaviours of harm, and one of the big areas of issue I have is trying to get appropriately trained staff to work with those people and then keep them there, because it can be a very challenging environment for any staff member where you may potentially have a client hit you. There's also issues in this area around restrictive practice and having skills developed, and I know that it's not really talked about in the training sector around what constitutes restrictive practices, positive behaviour supports, those sort of areas where we need recognition of the skills of those individuals and funding likewise to take account and to appropriately support those people. Certainly a big fear about the NDIS is that in this competitive market approach that's going ahead, that that with for-profit providers and other providers coming into the sector, that the people that probably need the most intensive support are more likely to be those who are going to find difficult to find a provider to provide a service to them, unless within the award and within the funding arrangements that is really strongly recognised. And it's not just about the award, it's about risk, workplace health and safety issues for those people that work in that area as well.
Other obstacles that people perceive?
I guess just to add to what Craig just said, I was speaking to a service manager the other week from a regional and remote community and supporting people with challenging behaviours in particular. She was saying because of the small nature of their town, one of the gentlemen they support has severe challenging behaviours and behaviours of harm, and no one in the town will actually support him. So what does that mean when you can't actually get a workforce in a regional area to support people? So they're not going to have one choice and control at all, or two options of what support looks like.
Other comments about obstacles?
We'll come up to the far north table. I'm sure they've got lots of obstacles.
We can mirror what everyone has said here around the issues of the equity of the award. So you have someone who's ambulant and can communicate well and just needs support in some empowerment and direction in the community, versus someone who's got high and complex communication barriers and behaviours that are associated with that. And the award doesn't have any allowances for that acknowledgement, so it's hard to get staff to then support that more complex client. And if it's based on need and someone gets funded at 20 hours because that's what they need, it actually is 2 staff per hour, so that's actually 40 hours that they need. So instead they get half the support that they're identified for. So I can mirror that. I will also mirror the flexibility around the award. So people who want to work across span of hours, and even if you want to develop an IFA with them, because the staff member saying it suits my personal need to do a broken shift that spans across the 10 hours, or I can do lots of shifts in a consecutive time, but they don't get remunerated with the appropriate overtime rates, even though it suits them for their own family reasons. So if they take that to Fair Work, it wouldn't pass the Better Off Overall test.
At the moment, that's probably true.
So that one's a huge issue, especially when you go somewhere remote where the limitation of staff is there. So if you're using close neighbours and family members and stuff like that, you might only have a choice of 2 staff members. And if you need support in the morning and late in the evening, that's going to be less than a 10-hour break, but across a 12-hour span. So therefore, it's going to be involved in overtime. And the only other one that I thought of was around respite house facilities and stuff like that. So under the NDIA, so it moves away from block funding. How do you keep a permanent qualified quality staff in a respite facility when you don't know what funding you're going to have to be able to support that service?
Good point. Do we have any other comments on obstacles? No? Okay. Okay, I think we've talked about a few of the elephants in the room. We've just talked about needing to employ staff who develop specialist skills for dealing with high needs clients or clients with challenging behaviours, but you don't feel that you can recompense them in a way to recognise that added value that that worker provides, largely because you don't feel that you can get funding for that person. And I think, yes, the award is a fairly broad brush classification system, and you could just put all your support workers in level 2, but I think the award does have a range of classifications, and you could decide to classify that person as a level 4 or 5. But I think still the issue would be, where is the funding coming to provide services to that particular individual, so that they're not going to go off and work for Rio Tinto or wherever they're going to find an organisation with money to spend on the added value that particular worker can have. I guess one of the other sort of elephants in the room, sorry, my batteries are a bit flat, is the issue of whether casualisation is inevitable. We've talked a bit around the room about the current casualisation practices? And what will that mean for developing a skilled workforce? You're all talking about employees who are more skilled, more diverse, with a diverse range of attributes and training. We know that staff value having a career path and a stable job, but on the other hand, does that mean that the new environment is working against that? And how can you maintain, because I've heard some quite profound messages from you about the value of your services and your staff's alignment with those values. So clearly you've been able to achieve a workforce which can provide services for people and have a staff who are aligned with your values. But does that mean that the new environment is going to mean that you're no longer going to be an employer of choice, that people aren't going to choose to come to work in the disability services sector because it's too hard and not well remunerated, they're not being well trained, they're not being well supported? I guess these are the things that you're facing with the new environment. How do you continue to maintain those high quality services that you do through your induction and your training and your individual workplace arrangements? How can you afford to do any of that in the new environment? And I guess that's why you're all spending all your time looking at business models. Just a word about how you can take the positive attributes of your current organisation into the future. Obviously, it's not just a matter of business models. It is a matter of trying to embed your culture into whatever new forms that you end up moving into. So your human resource management strategies will obviously be a really primary driver of the change in your workplace, and particularly around recruitment and retention. It's going to be really necessary to put a lot of resources and have a lot of ideas in that space about how are you going to get that workforce into your organisations, how are you going to keep those high value-adding employees you currently have. And it's true that there are some industrial hurdles to doing that, but that's really just the nuts and bolts of implementation. It really is, and I think a number of you have mentioned it, the quality of your management, the strategies that your HR can develop in order to push you along in this change and to bring your staff with you. And I think we've also just talked about, most of you didn't say, as some of the groups that I've been to have, that your existing workforce is an obstacle to change. You've all spoken very positively about your current workforce, but you obviously need assistance to move them to the new place. So I think that's very encouraging. But obviously there'll be different things that will be needed for maintaining your current workforce and attracting new entrants into the workplace. So I think this group, most of you are already well on the road to making that change and bringing your staff with you. But I just want to make the point that obviously your internal policies and strategies are going to be vital around this change. Now we'll just go on to some of the tools that you'll have to use to introduce some flexible employment practices in your workplace. And speaking to you, I can see that you already employ most of those tools. So I think when we're talking about the award, we get a bit unfocused on the fundamental engagement between the employee and the employer, which is the contractual arrangement. And I heard people speaking about the characteristics of both the workplace and management in terms of the need for clear communication and articulation of the values of the organisation. Well, when we come to contracts, I think that is a place where there's a lot of work to be done in the community sector generally, but particularly in the disability sector where you're looking at changing the nature of workplace arrangements. It's really important to look again at your contracts to see what flexibility they give you for being quite upfront about the nature of the work, the hours of the work, the changing nature of the hours. It is quite possible to employ part-time or full-time ongoing staff in a flexible way, so long as it is actually spelled out and agreed to. So I would put a caveat that it is not necessarily that easy to reduce hours, but in terms of contracting with staff to point out the variability of the hours that they will face, you can certainly do that up front through your contracts. And when you go to the NDS workshops and work through the guide that NDS has developed, there's a whole lot of clauses there around what type of clauses can you use to engage staff on variable hours. So I think focus on the contract as the first point in terms of setting up new work practices, and be as clear as you possibly can be with your staff about what the hours of work will be. And I've heard a number of you talk about how you already have those sorts of arrangements in your workplace and your staff are engaged with it, and because they know what the variability is, they're prepared to go with that, and for some of them it does quite suit them. So for permanent staff, whether they're full-time or part-time, it is possible to engage them on a contract and provide them with the certainty that they need without actually tying yourself down to only offering a certain number of hours every week forever. So it is possible to have ongoing contracts in this new environment. Obviously there's fixed term engagements, and I'll just ask the group, how many of you now use fixed term contracts? And can the table at the back tell me what purposes do you use fixed term, what contracts, what circumstances do you use those contracts in?
Well, our senior managers and care managers are on 3-year fixed term contracts.
And the care managers, is there a reason? Is it because they're perceived as management staff?
They don't manage any staff. They're
Right.
case managers, yeah. We just have, just because of the funding.
So it's funding related? Does it mirror the funding cycle, or
No.
is it because of the uncertainty of the funding?
Uncertainty in the funding, but it's a 3-year cycle, so whenever they start for 3 years.
And support staff, would you employ them on fixed term basis?
Yes, we have quite a lot of support staff on fixed term as well, especially project-related roles, senior admin roles.
So projects, yeah. Okay, what about the person next to you? No? Lady in the red shirt.
Ours would only be project-based.
Project based?
Yeah.
Yes?
We use contractor for our emergency on-call services, after-hours services.
That's an independent contractor arrangement? And can you elaborate on how that works? Who is the company, or is it an individual?
Individual with an ABN that provides the same service for a couple of different organisations. So they take over the phone answering capabilities after the office closes, and they cover the weekends answering the phones.
Okay, so you've shot down to independent contractors who, like casuals, are perceived as easier to engage and then disengage because it's not an employment relationship. But there are a few hurdles involved in the employment of independent contractors, and I guess just as fixed term staff are commonly either for backfill on leave or for special projects, you will all probably employ independent contractors of some type. For example, the cleaning service or the gardening service, they would usually be independent contractors. The issue I'm interested in this sector is whether we're going to get a situation such as you've described, where support workers or generalist caseworkers are coming in and acting as independent contractors. Of course, a lot of you would employ people through a labour hire arrangement from time to time as well.
I would imagine if for highly skilled support staff that come into, especially in that difficult area of disabilities with challenging behaviours, I could imagine that that would be a demand area.
They might see a niche for themselves. Certainly in Victoria, I've noticed allied health staff have filled that niche in terms of setting up their own business and consulting to clients or agencies.
We've already
as
got
independent contractors?
We've already got a number of support workers, I think, working as independent contractors. And at the beginning of Your Life, Your Choice, we saw a bit of advice go out to the sector that was probably in this technical minefield where families were saying to other families, you can easily just employ them as independent contractors, you don't have to worry about anything, but actually they were technically employees. So that's kind of been a bit of an issue.
Yes, that's what I was getting at, the sham contracting arrangements. But is that quite common, that genuine independent contractors would provide support services, or it happens a bit?
It happens a bit. I was sitting with a group of staff the other day from a small service provider, and one of their support workers has about 5 different jobs, and he's employed under, contract, as a casual, as permanent part-time, and as an independent contractor, depending on the job. Yeah, I don't know how he keeps his head straight about where he is, but so we already see it.
Yes.
Look, there is another issue, particularly with independent contractors and agency staff too, that we're finding, is that because you might employ them to work with you for a particular period of time, you don't know how many hours or what they've done in the period beforehand, which may then put them in a position where, if they are working with people with challenging behaviours, then potentially they're very tired, they may not be switched on and on the ball, and it can actually add to potential incidents and risk. And that's an area that we try and explore with any contractors that we know are working with our high needs clients, but it relies also on honest answers.
Because they're in control. I mean, the test for independent contractors is whether they actually control the service provision. And the reason why you don't know whether they're tired or been working 24/7 is because they're in control of the work. You're just engaging them to come in and do a service. And the same issue arises for part-time staff, where they're also working at other providers. You don't know whether they've just come off shift, an overnight shift, and they're coming to you bright and not fresh on Monday morning after working the weekend. And I've seen a number of contracts that you're all entering into now where if there's shared arrangements between a number of providers, you'll actually spell out in the contract what the employee, and this would be the same for an independent contractor, what their obligations are towards health and safety and becoming fresh and rested for work, and advising their employer how many other shifts they're working. So it's a common issue for workers' compensation in any case. You don't know whether the person has been injured on Anglicare's night shift or Uniting Care's night shift. It's a difficult point with part-time staff.
This is the point. I think it's a very grey area.
It is a grey area. We're pretty sure it will be the employer's obligation somewhere along the line, but I think there does need to be more stress on employees have obligations too, and independent contractors have obligations, but it's a useful point that you make. The other type of employment obviously is casual employment, and we're concerned about whether casualisation will grow in the sector and whether it will have the detrimental effects that some of us fear that it might. But there's no doubt that casual employment is a type of employment that's easy to engage and easy to disengage. However, it comes at a price. There's a minimum engagement of 1, 2 or 3 hours, commonly 2 in this sector, and it has a 25% loading. So obviously a movement to casualisation across the board would be quite an expensive one. The other issue about casual employment is that over time they become less attractive in terms of those things about easy to disengage and not so process driven as terminating their employment as you would have with an ongoing staff member, because if employees work in your workplace for longer than 12 months and they've got a regular pattern of work, then the Fair Work Act says that they're long-term casuals and they do acquire some entitlements. They don't acquire all the entitlements of ongoing staff, but they begin to look more like a part-time staff member and more like an expensive part-time staff member. You can still end their employment, but you have to give them a valid reason. You would have to give them notice. They wouldn't be entitled to severance pay, but they would be entitled to be given notice if they're being retrenched because you no longer need that shift or you can no longer afford that shift. So there are dangers with the issue of casuals because the longer they stay with you, the more rights they will acquire. And keep in mind that long service leave will always apply to casual staff if they stay in the workplace long enough. So they're just the same as other employees. If they fulfil the eligibility criteria for long service leave, then a casual who's been with you 10 years or 20 years will also be entitled to long service leave. And you may not, because often casual workforces grow like Topsy and you don't ever sit down and think, what are my leave obligations to this employee? You may not have made provision for that person. So you've paid them a loading all those years, which buys out other types of leave, but not long service leave. I've commented on the need to use contracts to spell out the arrangement, and I think there are a lot more flexible contracts waiting to be created by all of you. I think we're all a bit standardised in our way of writing contracts, and maybe it's a positive thing that the new environment will mean that we'll all have to go back to our standard contracts and look again about, are we actually being as clear as we should be about the hours of work or the nature of the work, and spelling it out more clearly. Then the other way of dealing with issues in the award which you may feel are an obstacle to flexible employment is obviously going down the road of an enterprise agreement, and a number of you here have had either enterprise agreements or enterprise awards. For those of you who still have them in force, a number of you will be considering whether you should renew them, and those of you who don't have them will be considering whether it's useful to go down that path. So I've heard various stories here today. So some people are quite happy with their enterprise agreements and will continue to roll them over. Others are concerned that they would like to go back to the award, which is a difficult thing to do, and others are wondering whether they should go down that path at all. Does anyone here want to articulate whether they're considering going down the enterprise bargaining path at the moment? You might not wish to talk about it in front of your competitors, your colleague organisations. Certainly it's an issue in Victoria. Disability providers largely have, they're not multi-employer agreements, which is an option if you're particularly cooperatively minded. But they're sort of template agreements which roll up old awards, and they have now found themselves locked in to staying on that agreement because it has lower loadings and other conditions than the modern award. So they really can't move off it, but they can't move past it, because every time you go back to Fair Work to renew an agreement, it will now be tested against the modern award, not against the old pre-reform awards which are bound up in your current agreements. So many of my members have found that an obstacle for bargaining. They can't bargain, but they can't go back to the award either because they're locked into old awards just by virtue of their cheapness. I don't think that anyone has that problem. Well, I'm sure there's an employer in Queensland, but most of you today haven't mentioned that being an issue for bargaining. And enterprise agreements, like awards, can have individual flexibility arrangements within them where the hours of work or other provisions can be changed. And we talked earlier about how those types of arrangements are not that flexible. Just a point again about contracts, because I'm looking at HR policies, which again are something that you will be using in your workplace to spell out the detail of any flexible employment practice that you have. But contracts and HR policies must be in accordance with the federal law, because they actually operate under state law, and any Commonwealth law, which by and large employment law now is, will override the contract. So if the contract says you can work 70 hours a week and this is the pay rate, that won't protect you from the Fair Work Ombudsman knocking on your door. But if it's just pointing out what the variability of the hours are, then it will be in accordance with the award. So contracts and HR policies, whilst useful for providing detail and, obviously in the case of contract, a legally binding instrument, do still have to be within the parameters of the Commonwealth legislation, which is the National Employment Standards and the awards. So we've got that balancing of the needs of the employee and the needs of the employer being utilised through a number of different tools. You've got your industrial instruments, you've got your HR management, you've got your business models that you're developing, and obviously it's an issue for you as to which way you go in terms of developing your workforce. But the industrial aspect of it is really just one part. I did want to make a comment about casuals and employing casuals, but we may well have already covered that. Is anyone here employing casuals in a traditional sense, which would be for short-term relief, backfilling absent staff, that sort of engagement? Yes. So that would be the most common form, unless you've got a particular service that is provided as a casual. Yeah. Okay, well that's the traditional form of casual engagements, but I think many respite services or accommodation services certainly have a number of long-term casuals on their books, and obviously the concern there is that over time it's an expensive way to employ people, because you do get tied into continuing to having to offer work to that individual, or if you are going to remove the work, to go through a formal process to take that work away and have a valid reason. There are difficulties in training casuals and ensuring they're part of your performance management of your organisation. I don't know if people have commented on the difficulty of actually supervising not just casuals, but staff in home-based services. And people have also commented about the difficulty in training casual staff, because they're just not present enough to fit them in, and if they're doing individual services, then they're not, you don't have the income to train, to bring a whole lot of casuals in off your casual pool and put them through a training course. And then of course this issue of whether you can recruit a big enough pool of casuals. I wonder if people here have gone down the path of having shared pools with other providers in the area. I've had a few examples of that over the last few weeks. Is anyone doing that, where you're actually having a shared casual pool? You do that? And does one person act as the employer, or do you just coordinate?
We've only just started doing it, and we're working through all those processes because of taxation and to employers, and dropping shifts that are longer, that are shorter for longer. There's often these people in that pool that we've found have got not just the two organisations, but they'll be on several other places, and find that you might require them to do a 2-hour replacement shift for someone that's gone home sick, but then they'll get a call to do a 4-hour shift, and they'll drop that shift and go to the other one, to another organisation. So you need lots of people in this pool and go through lots of contacts to get it done, sometimes to get a quick shift filled for.
Yes, the shared pool issue does throw up a lot of issues around privacy and the need to get information about other shifts for other employers. The issue of shared employment, which has come up in some of the workshops, has been around actually sharing of corporate services staff rather than support workers, because obviously a number of smaller organisations might already have quite a low resource base to draw on. Okay, I can see that people are looking at the clock and it's getting to 4 o'clock. So just go briefly to part-time hours of work and just point out where these provisions are in the award, and then we'll just finish up. The award provisions in the SCADS award do require that staff have some degree of certainty around their hours of work, but as I've said, you can use creative contracting in order to spell out what those hours are, and also you can obviously have a roster. The other options in the award are averaging of hours, and you can average hours of work over a month, so a week, a fortnight or a month, and I think that area is quite commonly forgotten, although you're nodding, maybe your organisation uses that provision. So you're not required to employ staff the same hours every week, so long as it's on average over the month, that's fine, and you can use an enterprise agreement to push that averaging out to 6 months. Many organisations don't perceive that you currently have rosters. I think the organisations here do, but I think many organisations think that their staff are employed for regular hours, when in fact it would actually be more expedient to view them as rostered staff, and that would fit more easily with a contract situation where you can attach a regular roster but it can change over time. And I'm thinking now of a number of youth services who run weekend services from time to time, but they actually haven't contracted with their staff about the variability of the work. It might be during weekdays for a few months and then it might be on weekends. So again, rostering is another way of using your staff flexibly across the award provisions. And obviously you can always breach the provisions of the award. You just have to pay a penalty. The penalty is either overtime or a penalty loading for shift work, weekend work, etc. So again, if you're designing services where it's going to be expensive for people to work long hours in excess of the span of hours or on weekends, you then obviously have to build those penalties into your costings for that business model. But it doesn't mean that you can't deploy the staff in that way, just because the award says that you can't work longer than 10 hours, or you have to have 10 hours break between shifts. Obviously, you have, for some services, you'll need to look at what is the cost of continuing the staff after those limits, and the cost obviously is a payment of an amount of money, taking into account, of course, the OH&S provisions. And I think the final issue in terms of the flexibility of hours of work in the award is around communication with your staff, and that contracting at the beginning, the induction, and the engaging the staff with how things work in your organisation, so that they're actually embedded with the values of the organisation and they understand the reasons for the nature of the working hours. And I think a number of you have provided examples here today about how that's effective in your organisations. Going on from today, I've already told you that there will be submissions for the Modern Award Review, and no doubt NDS Queensland will be consulting with its members around that. The NDS National is running a series of workshops on the nuts and bolts of flexibility provisions around the award and contracts in engaging people in flexible workforce patterns in your workplaces. And I've been doing some of those in New South Wales over the last few weeks. So that program will be rolled out in Queensland in the next few months, I imagine. And it will come with a guide and resources for doing this sort of contracting and engagement of staff in a more flexible manner. So watch this space for that. But thank you for your attention. You've been a very interesting audience, and thanks a lot for all your ideas, which I will take back to my next workshops. Thank you.
So check out what the Workforce Council team did with the very colourful, messy exercise they did earlier. They worked it all out. They've got 6 way more than that, classifications or groupings of jobs around the board. To start with, volunteers, professional roles and client services. So this is in the therapy space, behaviour, counsellors, OTs, Auslan educator, so on. Corporate support, all from development and training manager, field training officer, well that sounds official, and all through QA, WH&S, media support, development officer, workforce planning officer, that's a good job. Resource worker, resource and development officer. Then in management, which has got in brackets corporate. Oh, okay. So project manager for disability reform, service development and innovation managers, state managers, finance managers, payroll managers, managers everywhere, managing directors, general managers, directors, CEOs, EDs, and so on. A futures coordinator. Fantastic. Okay, there's some jobs I've never heard of. Management in terms of client services. So again, through the service manager, disability services manager, day respite supervisor, advocacy manager, centre supervisor coordinator, and so on. Paraprofessional roles and support workers. So some of the new ones that we hadn't seen before were host family support, host provider coordinator, hosting and self-managed funds coordinator, diversional therapist, employment consultant, arts worker, peer worker. It's incredible the variety in this, particularly in this one. Community enabler, challenging behaviour, disability support worker, and so on. There's heaps and heaps of them. Then you're down in domestic assistance, maintenance officer, and so on. Then the last category is around admin and office support, so finance, administration, bookkeeping, information officers. So that's where you put IT, was in there, around there, yep. So there you have it. Wish us luck with working that out. First stage of working it out. And thanks very much to the Workforce Council team for doing that work for us. Really appreciate it.